right, ladies and gentlemen, I think we have everybody here. We've got a full afternoon with plenty of witnesses. I want to see if we can't kind of limit the time on the witnesses, and we'll talk more about that as we get to it. Our first bill up is House Bill 334. Representative Gullett, if you want to make your presentation.
Sure. Thank you so much. I'm going to read my remarks because it keeps me on track as we go through, if you guys don't mind. We spend a fair amount of time updating laws to make it possible for citizens in Georgia to transact business in easier ways. When we get it right, we leave existing commercial and competitive dynamics in place, keep the playing field level, and simply make life easier on everyone. I believe this is exactly what we're doing with HB 334. This bill was introduced last year, and we realized in the process that we needed to spend some time between our sessions perfecting it because the large number of parties who had specific interest in the language. During the intervening time, we spent over 100 hours on video conferences, exchanging drafts, and painstakingly editing and re-editing the document. This work has resulted in something very close to consensus, which is unusual and very positive on a bill this complex that touches so many pieces of our economy. If we enact this legislation, Georgia will become the 30th state in America to offer remote online notarization and witnessing. Notably, we will then be the first attorney state, meaning a state that requires real estate transactions to be conducted by a Georgia attorney to enact RON, which is remote online notary, setting path for other states to follow where the process for real estate transactions is significantly different. I'm excited to see our state find a way to show the rest of the country that we have the ability to incorporate modern technology in real estate closings without altering the key role played by attorneys in protecting the interests of our citizens in what is often the single largest transaction of their life. I want to now outline two areas. I won't read the entire bill, but will generally explain where we are and what we're doing. Following the list, I will outline the remaining issues where we are close to an agreement, but need to incorporate technical changes. It is my hope we can pass this bill and have a substitute ready for full committee that will bring us the final and rare achievement of complete consensus on a complex commercial transaction bill.
All right, now Representative Gullett, before
Sure.
you go on, which LC are you doing this from?
It's LC 412880.
Okay, thank you.
Yep. Sorry, I should have announced that. All right, so following are the major provisions of the legislation. Number one, we allow the use of electronic notarial seals in any context where an ink seal is allowed today. The only exception is probate or fiduciary, where we felt the process would be better served by requiring a physical presence. Number two, to become an online notary, you must first be required to be an ink notary. You then have to take an additional course to be a remote online notary. And incorporating a suggestion from the closing attorneys, we've added a requirement for surety bond because they felt it was important for the notary to have financial skin in the game to ensure a valid remote notarial act. Number three, remote online notary license holders must comply with extensive requirements for using software that meets tight technical standards and retains digital process of audio-video recordings of the Notarial Act for 10 years. And this legislation subjects RONs, so remote online notaries, to penalties if they fail to do so. These requirements are significantly more extensive than those we apply to ink notaries. Number four, we also included language requested by closing attorneys to further backstop the principle that only Georgia licensed attorneys may engage in the practice of law. And we had the language in the bill that is important to the court clerks clarifying their duties to record. Number five, the regulatory entity for this regime is the Georgia Court Clerks Cooperative Authority, and we've done extensive work to establish firm standards for their regulatory process of remote online notary, while also allowing enough flexibility for the authority to accommodate changes in the future. In general, I would submit that remote online notary approach, the RON approach we have crafted, creates a process that is both more convenient and more secure than the existing ink process today. If you want to fake an ink notary, all you need is a computer and $10 to get one. If a notarial act is contested in ink world, we have very little evidence at hand. For remote online notary, you have extensive electronic documentation of the process, in addition to the audio-visual video recording of the parties interacted, meaning disputes around validity can be much more easily settled. I now want to turn to the areas where we anticipate some additional changes in a substitute. First, the Bar and the Community Bankers Association have identified some technical changes that perfect the bill. None of these issues are in dispute, and we look forward to including them. Second, the language added by the clerks regarding recording duties has raised some highly technical issues tied to consent litigation around constructive notice. I am told by both parties that we're close to having final language on that. I'm going to put this issue to rest and plan to include that as well. Finally, while the bar is good with these provisions as they stand, the closing attorneys have a separate association representing their interests. They have requested some additions on top of the surety bond and unlicensed practice sections in the bill now at their request. These additions would create a civil remedy for the willful recording of real estate documents that were not prepared by a licensed Georgia attorney, require notaries closing Georgia real estate transactions to be licensed in Georgia, and require notaries participating in closing to be located on Georgia soil during the closing. We're working through some challenges faced by our industry partners on these issues, as well as some constitutional concerns. I believe we're close to a solution and look forward to including that in full committee substitute as well. I ask for your favorable consideration as we discuss this bill. In addition to general commercial benefits of this bill, it can reduce the need in face-to-face for routine transactions and plays an important role and an important part in our COVID response. I want to thank all the attorneys, court clerks, and industry experts who have put so much time in getting us into a great spot on this bill, and I urge, great discussion in this. Let's figure out a way to get this thing done.
All right, thank you, Representative Gullett.
Thank you.
Is there anyone that has any questions? How about online? All good? All right. Thank you, Representative Gullett. We're going to move on to the witnesses on your bill. You may want to stick around if you have time.
Yeah.
I understand you have another presentation.
I do. Thank you.
All right. Sydney Rubin are they online or digital? Sydney Rubin online?
She might be in the hall, maybe.
She's here? Okay.
You wanted to sit here?
If you want. You can slide down.
I
And
will, yeah.
Ms. Rubin, if you would come right up here. All right. Tell us who you are and who you represent.
Good afternoon. My name's Sydney Rubin, and I represent the Georgia Credit Union Association. Thank you very much for having me this afternoon. I'm very appreciative for the opportunity to speak in front of you all today regarding this bill, House Bill 334. GCUA represents the 68 credit unions with almost 2 million members across the state of Georgia. We are here in support of the bill. We're elated to see the pursuit of remote online notarization in Georgia and believe that Georgia should be added to the list of the more than 25 states who have already enacted RON laws. RON laws allow businesses to complete important transactions requiring signatures and a notary seal remotely via online technology, as Representative Gullett has already gone into great detail on that. We're grateful that Governor Kemp granted temporary remote notarization via executive order on March 14th, 2020, and believe that the state's credit unions would greatly benefit for making this digital transformation permanent. Credit unions are not-for-profit financial institutions without external shareholders that exist only to serve our members and most operate with a leaner budget and staff than other financial institutions. Therefore, credit unions must embrace efficiencies to give their members the best possible service. A permanent remote online notary law would provide credit unions a boost of efficiency that will translate directly to benefits for Georgia consumers. For these reasons and many others, we encourage members of the committee to support this measure. Thank you very much.
All right. Any questions of Ms. Rubin? All right. Thank you, Ms. Rubin.
Awesome. Thank you very much.
Next is Mike Holloman.
Yes, Mr. Chairman, this is
I
Mike
don't know if
Holloman
he's
attending
online or outside. Is he online?
online.
Turn it down.
Okay. Mr. Chairman, this is Mike Holloman. I'm
Mike
here.
Holloman, are you there?
Yes, can you hear me?
Oh,
He's talking. He's in the middle.
I see him. Okay.
I am not on mute.
Mike, hold on a second while we get the, resetting. Yeah, you're gonna get feedback. All right, see if we can hear you now, Mike.
Can you hear me? Am I
No?
still can't hear?
All right, hold on just a second.
I assume that those of you who are participating via Zoom can hear me. Can I get a thumbs up if that's the case? Okay. Just making sure it's not on my end that's the problem. I do think it's in the committee room.
Go ahead and see if we can hear him now.
Give us a test, Mike. Can you
Can you
hear?
hear me now?
Yes,
It's on
it was
mic.
coming
Okay.
through him.
Go ahead.
Well, this may be, Mr. Chairman, thank you. This is Mike Holloman. I am here today representing the Superior Court clerks. And this may be a little anticlimactic since we are in support of the current draft of the bill. We are aware of the hanging issues that Representative Gullett outlined in his presentation. We're not fully committed on one of those, but we do foresee a path forward, and we'll continue to monitor and work with Representative Gullett. But we do support the bill, especially as currently drafted, and I think we'll likely support the bill as it gains these additions that he referenced. That's all we have. Thank you. Now I don't hear you.
Questions for Mike Holloman? Yeah, I had my mic off. All right, I don't see any.
All right, thank you.
Mr. Holland. Mhm. All right, next is Renee Hunter.
Good afternoon, Chairman. Good afternoon, Vice Chairman, and also good afternoon to all the members of the House Judiciary Subcommittee that could join us. Can you all hear me?
Oh, yes.
Excellent. My name is Renee Hunter, and I'm here on behalf of Notarize. I serve as Notarize's general counsel and have been their general counsel since February of last year. Notarize is a digital trust provider. We're a platform that integrates technology with live human interaction to establish identities. We offer digital identity proofing and authentication services, including a market-leading notary public platform to allow any person or any organization or business to get their documents notarized online 24 hours a day, 7 days a week. Our mission is to help people execute the most important transactions of their lives. and make notarizations more convenient and secure through enhanced authentication and integrity preserving protocols, which create non-reputable records. Access to digital services is clearly more important than ever right now. And at Notarize, we do applaud the activity to ensure remote online notarization works for not only consumers, but also notaries, attorneys, and all industries in Georgia. We want to thank Representative Gullett, as well as Representatives Jones, Leverett, Kelly, and Burchett for authoring HB 334, which, if enacted, as you've all heard, will allow for notaries commissioned in Georgia to perform remote online notarizations. We fully support HB 334 in its current form. It's just a very brief statement I wanted to make because we do actually support it in its current form. In closing, we want to thank again Chairman Gunter for bringing forth this bill and the subcommittee for taking HB 334 into consideration. Of course, if you guys have any questions, always happy to answer them, but thank you again.
Thank you, Ms. Hunter. Anybody have any questions for Ms. Hunter? Nothing online. All right. Thank you, Ms. Hunter. We'll go next to Lori Godfrey, Community Bankers Association.
Hello, Mr. Chairman. How are you?
Good. How are you?
I'm good. So thank you for taking the time to listen to my testimony today. I'm Lori Godfrey, and I work with Community Bankers Association. And today on the Zoom call, I have John Saleh with Adams, Hemingway, Wilson, and Rutledge, who helped CBA review the different versions of the bill that have been circulated. First and foremost, I want to thank Representative Gullett and Brad Alexander of Impact Public Affairs for working with CBA to incorporate a number of our edits in prior versions of House Bill 334. We acknowledge that House Bill 334 is the result of years of effort among key stakeholders who have worked to craft legislation, preserving our traditional notions of notary public, while also expanding the concept of notarial acts into the digital age. The importance of this legislation continues to be highlighted as our state and country navigate the effects of the COVID-19 pandemic. Because of this, CBA does support House Bill 334. However, there are some provisions in the bill that cause us concern. Namely, House Bill 334 contains a multitude of highly technical requirements related to remote online notarization and electronic in-person notarization, and places the obligation to comply with such requirements squarely on the individual notary. And on paper, it makes a great deal of sense to impose these requirements and for the burden of complying with such requirements to be on the notaries themselves. Practically speaking, however, we are concerned that the true cost of failing to comply with the requirements imposed upon the notaries will fall upon the person seeking to enforce documents executed through remote online notarization. As drafted, House Bill 334 could be read to invalidate notarial acts that are not performed in accordance with standards set forth therein, which in turn could have cascading effects on a financial institution's ability to enforce their rights under such documents. Because of these risks, we believe that a financial institution's relationships with notary publics, specifically remote online notary publics, will become more formalized, and financial institutions will be required to underwrite the risk of the new vendor relationship to ensure that the remote online notary can comply with applicable standards and has assets sufficient to make the financial institution whole in the event that the notary falls short of their duties. For better or for worse, we believe that this process will necessarily reduce the number of available remote online notaries, or at least aggregate such notaries under the umbrella of relatively few third-party service providers. The end result, we believe, is that it will be very difficult for community banks to get comfortable using in-house remote online notary publics to close loans via electronic means, and instead will need to add yet another vendor to their vendor risk management program.
Technology that's being adopted, and you've done a great job of getting everybody at the table to discuss these things. So just wanted to read a little bit about what our belief is. So we really do thank Representative Gullett for doing this, and I agree. I mean, all of our livelihood depends on the fact that Georgia's a great place to do business. I mean, we are, as closing attorneys, we thrive on that. We live on that. That's what we are. So we definitely want to help in that process. And we also understand the need for remote notarization for so many documents. There's a myriad number of ministerial documents that really need to have remote notarization. And And the impact of it being in person really doesn't make that much difference. And those types of things are like notarizing a purchase order for a copier, notarizing an affidavit of a lost receipt for reimbursement, notarizing a health and medical related document for care of a loved one. So those are things that really, I mean, having the remote technology is really a great thing. Our real concern is to ensure that consumers in our state are protected in the purchase and sale of their most important assets, which is their home. Their homes have become their castles, particularly in COVID, and they've become their refuge and their sanctuary, and they've also become the most significant asset that most people in the state will ever have. So to that end, Representative Gullett has asked for us to comment on the bill. And there are a couple of things that we would really like to see that are incorporated. And that is that only Georgia licensed attorneys continue to conduct closings in the state. And I think that on a conceptual level, he's agreed with that, how we make that happen. And I might misstating that, but I think that he's agreed that that is the current law and that is and that's acceptable. And the other thing that we are really concerned about is that a Georgia citizen or a Georgia property owner who elects to use a remote online notary, that they would be afforded the protections that are already carefully thought out in Representative Gullett's proposed legislation. Last year, we were not big fans of the bill because the bill did not have a lot of the security measures that were in the Model Act. They were it was not as robust in all of its technology, security, identification, all of the things that Mr. Brandon talked about. So this bill is much better. It really does go far into that. But one of the things that it does say in the bill, in the later parts of the bill, line 434 to be exact, is that a notary public or remote online notarization done in another state has the same effect as one done in the state of Georgia. So that means if you're like Virginia has a very, very lax notarial remote online statute. It is not nearly as robust as ours. It does not follow the Model Act. And that means that if somebody does a remote online notarization in the state of Virginia and records it in this state, we have to respect that as something that has been properly notarized. And that we believe strongly that diminishes the integrity of the whole process. It should be a Georgia notary doing notarizations within the state of Georgia. Now we can of course have remote experiences. We can remotely notarize the document for anywhere, for anybody anywhere, but the notary would be in the state and would be commissioned by the state and would be under the rules of this well-drafted bill. I mean, why would we let somebody backdoor their way through it and then they don't have to follow the rules that we've set forth in this really good bill. So I do think that this is also, one of the comments earlier was a latent defect. So a lot of the statutes you don't know if it was done by a remote online notary. You don't have any proof that it was done by a remote online notary. So is that going to be a latent defect? I don't know, but that portion of that bill, we would really like to see revised so that at least if it's going to be a real estate document that deals with your home, that is one that has got to be done by a Georgia notary under the guidance of this. And we also would like to have the in-state presence of somebody. It is important that we have somebody to go to. So I don't know if you've ever been to the record room, but in the record room, it tells you who closed a transaction. And it tells you all, you know who you can go to when you've got a problem with a document or you've got a problem with a closing. And if you deal with all remote people, nobody located in the state of Georgia, our experience so far has not been awesome in that regard. We are not getting much feedback. We can't get title matters addressed. And that is the closing attorneys can't, but also the consumers can't. I mean, who are they going to go to have redress? Because the notary, neither in the current draft, neither the notary or the attorney have to be in the state. They just, the notary can be a notary of any state, and the Georgia attorney just has to be a licensed Georgia attorney, but not the state. So the presence of somebody that can walk the property, that can explain the documents, that can be part of the process, and also be a recourse for the borrower is an important piece, we think. We do like, we do like some portions of this remote notary bill. We recognize that technology is coming. It is a very divisive subject, I have to tell you, even amongst our board, it's a divisive subject because everybody is a little afraid of what it might do for their ability to compete and with people that have a lot of depth and a lot of technology and a lot of money to put into technology. And so what will that do for the hometown practitioner? We don't know. Everybody has to get up to speed to some point to be able to do this, to do some remote or to have technology to be able to do it. But it's what's been proposed is somewhat costly and may leave some people just unable to do it at all. So
Okay.
the two requests that we have primarily on this bill are that we have the Georgia, it be a Georgia present, we have Georgia presence, and that we have the UPL, that the unauthorized practice of law provisions are included in the bill or referenced in the bill.
Okay. Thank you, Ms. Brown. I believe I have a question from Representative Oliver.
In relation to paragraph C, beginning on line 434, you suggested that you wanted a revision. Do you want a revision or do you want a deletion?
Well, originally we thought maybe we should delete it, but then we were afraid that if we deleted it altogether, it would be unclear. Could you really accept the notary of another state without?
If you delete it or if you make it unclear that the notary cannot come, the impact is that you don't want a notary in Tennessee used in any way under the statute. Is that a simple analysis of what you're saying?
For at least for real estate.
For real estate, understand?
That was the qualification that I was
So
thinking
the
that we
real
could make to
estate
that.
lawyer has to be in Georgia and the notary has to be in Georgia. So remote notarization is only going to be allowed for people in Georgia.
No, you're remotely notarizing a signature from people all over the country. So it's only the people that are doing the remote
signer.
act.
The signer, I
The
see.
signer is going to be anywhere in the country or anywhere out in the world, really.
So if you're Rocket Mortgage and you want your notary to be in Tennessee, you're just going to have to make them drive over to.
Well, I
whatever.
don't care so much about the physical
Whatever.
presence as I would that it be a Georgia remote notary. I mean, if you're going to do a notarial act in Georgia on the remote basis, then, I mean, notaries, we respect notaries of states all the time. That's the full faith and credit part. We have to respect actual physical notaries on documents of other states. But it's the remote piece, because the regulation in those other states of that remote piece is not as robust as ours is. So we can't ensure that when somebody transfers property in Georgia and they're doing it under a remote notarization of another state, that it has the same safeguards.
Mr. Chairman or Mr. Gullett, did you intend for amendments to be offered today, or what's our process today?
I'd like to offer a substitute. So that way I think it'll make it clear for everyone. So it'll be a substitute at the next hearing.
But not today.
Um,
We're not going to be looking at language today. That's my question.
I don't know. I mean, I guess it's up to the chair. I wasn't sure if this is hearing only or if it's, I think you can only do amendment after a motion to do pass, I believe. So I'm not up to the formalities, but I believe that's the case.
And you don't have an actual substitute drafted yet
I do not.
with all of it.
We're close, but
And we have been involved in that process and very much appreciate that. But those are two main things. We want to be able to call somebody in Georgia and say, Can you tell us what happened here? Can you get us information? And the consumer also wants that when it's their house. I mean, they may not care so much about a ministerial thing, but their house, it's a big thing, and you want to be able to talk to somebody in the state that had involvement with it.
Generally speaking, you favor the bill, is that correct?
Yes, we do.
Okay. Just what you've mentioned is what the part that bothers you?
Well, I have to tell you, there are a lot of closing attorneys that don't think they think that we should oppose it. And we appreciate having been involved, and we know that it is a technology that is here. It is not going away. We know that it's a technology that a lot of people support. And if we can do it right, if we really can do it right, it won't cannibalize their practice like they think it's going to. But we have to make sure we put those safeguards in there.
All right, thank you. Representative Oliver?
Just for my clarity, I'm on the State Bar Legislative Committee. This has not gone through the Legislative Committee. You remember not remembering that correctly?
No, it hasn't. We have.
And there is no provision for the real estate section or the family law section or any other section to take a position. So that's the reason you don't have a position today unless it goes through the Legislative Committee. Am I right about that?
That's correct.
Okay.
I think.
He was shaking his head on the screen.
Oh, is that?
Mr. Brandon?
Hey, Rod.
I think this did go through the legislative committee.
No, this.
Not this particular draft that we have in front of us right now, but the earlier draft of it did that was very similar.
Does the state, that's my question, Mr. Chair. I don't remember. I should remember, but I don't remember. Was it in 19 or 20 or 21, 20 or 19 that it was adopted by the Legislative Committee of the State Bar?
It was in 20 or 21. Amy, do you remember? I mean, it was fall maybe.
It's 19. I think it was 19, but I'm really not remembering. I just want to know if the State Bar supports this bill. And then the Executive Committee has to sometimes revise their opinion, and I'm just asking for a process question.
Okay.
I don't think this is something that anybody really realized until they dug deep into the bill. I don't know if this is something that the State Bar considered or not, because I was not involved with that process. But we know what it's like to try to deal with people, all of whom are not in our state, and we need to have some connection, particularly with the remote online notary, that where we can connect with the people about a closing. The integrity of our records depend on it.
Any other questions? All right, does anyone have any other questions?
I just want to make a statement. I just got a text that the State Bar does support the bill, and it did go through the process. I'm not sure what that means, but that came from State Bar.
Who is that from in the State Bar?
Mark Middleton.
Oh,
He's a
okay.
lobbyist
Thank
with them.
I know it went through their process a while back. I'm not saying, they of course have an opinion on it. And I do think that there's a difference between a residential transaction and a commercial transaction. I think that the consumer in a residential transaction expects the person who's doing their closing to be a lawyer and to explain the documents to them. So it's a little different, and a lot of times that's why the nuances are not quite as recognized, and they're a little different in commercial than they are in residential.
All right. Any other questions? I think we've got it.
Okay, thank
Thank
you.
you, Ms. Brandon. Are there any other speakers on this bill? Hearing none. Thank you, Representative Gullett.
Thank you.
And thank everyone for their input on this bill. We'll be bringing this back probably next week or so.
Yeah, thank you.
All right, Representative Clark. All right. Welcome, Representative Clark. Finally got you here. And if you would talk about the LC number and then go into your bill.
Okay. I'll be working, have House Bill 109, LC 289964. For those of y'all that are returning members to the committee, you will remember we worked a lot last session and even in the off season before last session on this piece of legislation. And for those of y'all that are new to the committee, I look forward to working with you this session on this as well. What we have here is the Child Victim Protection Act. It specifically deals with victims of child sexual abuse and the organizations that potentially knew of it happening within the organization. And so I'll just walk through the bill and explain what it does and answer any questions that you might have.
Thank you.
So lines 19, well, actually line 20, it moves from a 2-year to a 4-year window for age of discovery. The current law is a 2-year. If a victim discovers, something happens, the memory is suppressed, or they didn't even know, they were too young when it happened, and then they get older and they start to realize what had happened to them. Current law has a 2-year time of discovery window. This moves it to 4 years. Paragraph B, starting in line 23, is just some cleanup language. There are the changes in that section. And then line 31, it moves the statute of limitations from 23 to 38 years if it happened on or after July 1st, 2015. If the act that was committed against them happened on July 1st, 2015, that's up in line 17. So this would move it to the age of 38. I think this is it's important to note here that the age of discovery, the average age of discovery is 52. So this age of 38 even falls below what studies have shown being the age of 52 for age of discovery. Moving down to starting in line 55, this is where most of the controversy is going to, or feedback you're going to get on the bill. It opens up a 1-year window for a look back for entities who knew that it happened. It's not that we took out the should have known language last year. They had to have known that it happened, and they concealed or covered it up. And I think it's important to notice that in line 75, 74, and 75, that the look back can only go back to the date of July 1st, 1988. So a question there, why stop there? That is the date, working with people last year, that there was a consensus even on those that opposed the bill, that these organizations that we're talking about became mandatory reporters. So the look back is only going back to the point where even they agree that they broke the law by not reporting it, that they worked to cover it up. And so it's not only that they were supposed to do the right thing, it's that the state of Georgia said, you have to report this. And these organizations violated and basically committed criminal acts themselves. So that's an argument that's often brought up in this. Why don't we just go after the criminals? I believe we are, because these organizations committed crimes by not reporting it. They broke the law. So that goes down through line 81. And starting in 81, it waives sovereign immunity so that we are going after public and private organizations and entities. That was some feedback that both the people for the bill and had concerns over. I'm not going to say people are against the bill, but people have concerns that they were like, why are you only going after private organizations and not public? And so we worked last year to include and waive sovereign immunity, and explicitly waive sovereign immunity with that language in 81 through 83. So as you look through the bill, there's different stages of burden of proof. For the standard, for the statute of limitations and the expansion, the burden is a negligent standard. For the 4-year date of discovery window, it moves up to a gross negligent standard. And then for the look back, going back to 1988, it is a clear and convincing standard, that the burden of proof of having to prove this falls on the plaintiff to the highest standard in civil court, being clear and convincing, that they have to prove that the organization knew that it happened and worked to cover it up. So with that, I do have some people from the Cease Clinic out in Athens that they've worked with me. I believe they've signed up to testify, Emma Hetherington, and she's kind of she can kind of go over what's happened, how this would impact the state of Georgia. And I know some members might have some questions because other states have done this and they would be curious as to what's happened. And she has with her somebody, Catherine Robb, who is with the Child U.S. Advocacy Group, that she can address some of the national implications of what's happened in other states that have done this as well, because to make sure that, well, just to answer some of those questions as well. So
right.
With that,
So
Mr. Chairman.
Thank you. Is there a particular order of witnesses you want to start with?
Well, I would prefer Emma Hetherington with the Cease Clinic. She's kind of a more of a subject matter expert on this than I am, and she could also address what she does in this field in Georgia and how this law would impact the state of Georgia, some of the technical questions that you might have.
All right. Then,
and I don't know how, you said earlier today that there was a lot of people that have signed up. I don't know how many. So
we have quite a few. Before we go to Ms. Hetherington, though, let me ask the committee if anyone has any questions of the author of the bill. You see you there. Okay. All right. Ms. Hetherington, can you hear us?
Yes, I can.
We-
Can you hear me all right?
Yeah, we hear you just fine.
Great.
Go ahead.
Thank you. Good afternoon, Chairman Gunter and members of this subcommittee. I very much appreciate being here. As Representative Clark mentioned, my name is Emma Hetherington. I'm an assistant clinical professor at the University of Georgia School of Law, and I'm also the director of the Wilbanks Child Endangerment and Sexual Exploitation, or CEASE Clinic. I first and foremost must say, as a member of the University of Georgia community, that I'm not here to endorse any specific legislation, nor am I here to lobby. The information I'm providing today is from extensive research on civil statutes of limitation and on how the civil legal system can be a place of healing for survivors and the community. The CEASE Clinic provides free legal representation to survivors in both civil and juvenile court proceedings. Under what was the Hidden Predator Act of 2015, we filed 6 civil lawsuits under the open window that was created under that statute. We also serve as a teaching and research center for attorneys, social workers, and survivors across the state and nationwide. We provide extensive community education and research as well. So what I wanted to talk a little bit about is what has been the effect of the Hidden Predator Act of 2015 that I mentioned. So effectively, that law capped claims at age 23. Now, the 2015 version did include a delayed discovery provision, but I think it's important to note that no claim in Georgia has been filed under the 2-year delayed discovery provision. Now, why is that? The delayed discovery provision, as written in 2015, would only apply to abuse occurring on or after July 1, 2015. And I would like you to bear with me and my bad math for just a moment. So if a child is 17, July 1, 2015, and they're abused, first, to take advantage of the delayed discovery provision, they would have to be over the age of 23. That 17-year-old would not turn 23 until 2021, which is where we are today. So there have been no survivors that have benefited from that provision. And I think that that's important for this subcommittee to consider. And then also, as mentioned before, there was that 2-year open window. It was only applied, though, to individual perpetrators, and entity liability was specifically excluded. As a result, there were fewer than 15 claims that were filed across the state of Georgia during that time. And as I mentioned, 6 were through the CEASE Clinic. And I know that as Representative Clark mentioned, House Bill 109 is a complicated piece of legislation. I think that there may be some questions about what it would look like on the ground. But before I get into that, I wanted to address sort of the elephant in the room. Why should we hold entities liable for abuse when they weren't the ones who committed the actual acts? Since 2005 and the discovery of much of the Catholic Church abuse out of Massachusetts, some of you may have seen the movie Spotlight, for example, and what the Boston Globe did up there to discover this abuse. There are a number of studies out of John Jay College, and they coined this term called institutional child sexual abuse. And now it's something that's harmful to not just the child, but the community at large. An institutional child sexual abuse is sexual abuse of a child by someone employed by or who volunteers with an organization where they work directly or indirectly with children. This abuse involves the inappropriate use of power and authority. We typically see this where an organization has a hierarchical structure of unequal power between the leaders and its members. And the leaders are in elite positions and have moral authority over those members. Finally, and most importantly, those organizations use systematic tactics to protect the offender and the image of the institution over the child and the community. And of these studies as well came out a lot of information about how institutional child sexual abuse harms not only the child, but the community at large. These organizations are often charged with the child's care, religious, moral development, as well as the religious and moral development of the community. Discovery of that institutional betrayal can exacerbate the harm felt by survivors. It can also create distrust and anger among the community, and losing community trust in an organization can be psychologically and spiritually harmful to everyone. And as Ms. Robb, I'm sure we'll speak about later, who Representative Clark mentioned earlier, there are heavy financial costs of that abuse that is felt throughout the community. And so opening up civil liability towards entities can reallocate those costs on the wrongdoers. One question I get a lot, and I've gotten a lot in the past in these hearings, has been, well, are we going to see this floodgate of litigation? Well, based on our research, we've not seen any state where there has been what we would consider a floodgate of litigation. We have to look at the actual number of filings under those open windows. So example, in New York, there was the Child Victims Act of 2019, and I'm sure we also saw those headlines. First day, hundreds of claims are filed. Well, in reality, when you look at the total number of filings under that window compared to the total number of civil filings that year, the total state civil filings only increased by 0.097%. That's a very small fraction. And most of those claims were filed on that first day of the open window. And in fact, the legislature realized that there needed to be more opportunity for survivors to bring claims and extended that window once it closed after that first year. And then the last thing that I also would like to point out is Representative Clark mentioning the July 1, 1988 date under the proposed open window, and that being sort of a limitation of how far back that open window should go. The assumption that child service organizations such as Boy Scouts, churches, et cetera, would not have been liable in Georgia until 1988 is actually incorrect. If you look at the history of the mandatory reporter statutes in Georgia, it was really first in 1973 that any other professional that is, quote, charged with the responsibility for the health, welfare, or education of a child was included in the mandatory reporter statute. In 1974, there was further expansion in Georgia and across the country as a result of the Child Abuse Prevention and Treatment Act, which was federal legislation. That CAPTA is what it's the short version. It provided federal funding for states that added civil and criminal immunity for good faith reporting. So the amendment that was done here in 1974 was meant to expand, not limit the statute. And also of note, in 1974, the amendment specifically added reports of suspected sexual assault. It wasn't until 1977 that our statute declared that willful failure to report child abuse is a misdemeanor under Georgia law. And then the 1988 statute specifically did add the term child service organization personnel. However, child service organization personnel were already meant to have have that liability or be mandatory reporters under that statute. And I think there's the confusion comes with, well, why take out this broad language that was brought in 1973? Well, the law professor that I am has to tell you that we can't just look at statutory language and in the history, but we also need to look at how our courts are interpreting our statutes. So under Georgia common law, a person or entity charged with the care of a child has always owed a duty of care to that child, even before the mandatory reporter statutes came into effect in the 60s. And it has always been a part of our common law to require those persons or entities to protect children in their care from abuse and by its employers and volunteers, particularly when they knew or should have known about that abuse. Our common law already provides ample protections for entities. For example, our courts, specifically in 1991, Supreme Court of Georgia interpreted the mandatory reporter statute to trigger the obligation to report child abuse or neglect only when the reporter actually has reasonable cause to suspect abuse and yet knowingly and willingly fails to report. And again, this is already part of the law in the state of Georgia. So I have to say, the limitations set forth in House Bill 109, while I think that they are an attempt to balance the various interests that may be affected by this bill, what it's really doing is it serves to further protect those entities, and it's failing to provide ample justice or access to justice for survivors. So those are the remarks I have prepared, and I'm more than happy to answer any questions related to any of my testimony.
Thank you for your work very much. I know your clinic came into effect after the 2015 statute, in part in response to that. I've been following y'all's work and admiring it. Would you please give me an update of the impact of Georgia's statute today as it relates to victims of the Boy Scout corporate entities and its determination of a bankruptcy approach to these cases? What are we doing to victims or for victims if we don't change the statute today?
So I first have to say I'm not an expert in bankruptcy law. And so I say this response with some caution, and I know that there are some attorneys here that can testify as to how the Boy Scouts bankruptcy has specifically affected their clients who are residents of Georgia. My understanding is, in many ways, it has put survivors of abuse here in Georgia at the far back of the line to receive restitution. And that's because our current statute of limitations is so limiting.
Thank you.
Okay. And Representative Evans.
Thank you, Mr. Chairman. Thank you so much for your testimony and your work. I am hung up on the 1988 date as well. Can you, and if you're not the right person to answer this, maybe it's Representative Clark or another witness, but the legislature generally, particularly this committee, typically doesn't like to pass legislation that's going to impact existing lawsuits. Are there existing lawsuits right now about entity liability for actions prior to 1988? Can you speak to that, or could you tell me who might be able to?
So I believe Darren Penn is here, and I know that he is an attorney of record on some lawsuits currently. I can say that those lawsuits were not filed specifically under our civil statute limitations because of that limitation, and were filed under public nuisance and fraud theories instead. And so this law could affect those lawsuits, but it depends on what it looks like. And if it cuts off the pre-1988 abuse, those claims could potentially go forward under those other theories of statutory tolling.
Thank you.
Any other questions? Representative Leverett.
Thank you, Mr. Chairman. Thank you for your testimony. And I had, just to make sure I understood the argument about the proper date at which entities could be liable. If I understand the analysis, you're referring to the effect or scope of statutes that mandated reporting of incidents of abuse and when they were amended to, I guess, require reporting, which could arguably have applied to some of these entities that might be impacted by this legislation? Am I following the reasoning?
Yes. I'm really only speaking about the mandatory reporter history because of the 1988 language in the proposed legislation, and that is correct. So really, it was 1973, based on my research, that entities such as those child service organizations would be potentially liable. However, as I also mentioned, under our Georgia common law, they would have already been liable anyways. So liability is different from the requirement to report. That's a different standard. And so they were already liable under our tort laws. It's just that there was now this specific statute that they were also required to report.
Okay. And do you happen to know what that specific statute that you're referring to, what the cite to it is, or is it in the criminal code, or?
It's our common law. It's our common law. It's through the courts. It came over from England and has continued in the state of Georgia.
Well, no, I was asking about the specific reporting statute.
Oh yeah, it's OCGA 19-7-5.
Okay, thank you.
You're welcome.
And just as a little history and background on the 1988 date, when working with this, starting back in 19, is when I had the idea to include the mandatory reporting statute date, and we did introduce it as the 1973, but through the process and committee work last year, it got moved to 1988. And this bill that we have before us today is exactly how the House passed it out last year. Just brought that same version back that had already gone through the committee process and out of the House, and brought it back to work back through the committee process this year.
All right. Anyone else have a question? You have another member of the Cease Clinic, Marlon Wilbanks.
So just to let you know, he is not a member. He was our major donor of the Cease Clinic and donated the funds to University of Georgia. But just to clarify, the Cease Clinic is specifically University of Georgia.
Okay, I had him down here as someone from your clinic. So, Mr. Wilbanks, did you have anything you wanted to say?
I do. Hello, Chairman.
How you doing?
And other subcommittee members. I'm doing great. I hope you are. We go back a long time.
Yes, we do.
Yes, as Emma mentioned, I am involved because I saw a need, Chairman, when we passed the law that was intended to actually help our victims of child sexual abuse. But there was a big gap because many of these victims, even if there was a law to help them, couldn't afford an attorney. And they just didn't have access to the ability to take advantage of the little crack of daylight that we had when we passed the first iteration of, I believe, what we call the Hidden Predator Act. One thing that Emma did not get into, but that maybe Darren may mention it later, but that everyone should be aware of, is the very sad fact that Georgia has lagged behind almost all of the other states in the United States in looking at creating access to the civil justice system for our victims. And of course, Mr. Chairman realizes that not only is it important to allow the victims, when they're able to come forward and speak against the abuse that happened to them, so that we don't re-victimize them by keeping them out of the court system. It also saves lives and souls, because exposing predators in a community is very important. And it's really a major win when that occurs. Georgia, to look at what Georgia, to look where we are today and why we are so much more draconian in our allowance of victims to get social justice, you do have to look specifically at the state by state analysis. And last year, the clinic was asked as the Cease Clinic on behalf of, as an arm of the state, not as an advocate, as Emma said, to go out and look and compare our state to all of the other states. And the bottom line, Mr. Chairman and subcommittee members, is that all of the other states that surround Georgia have more pro-victim statutes that recognize the rights of the victims of child sexual abuse in a more progressive and open fashion than we do. And there's absolutely no reason why our children deserve less than the children of South Carolina, Alabama, or for that matter, over 40 states across the United States have been put forth against this bill are tired arguments that have been defeated in the other states. The language of this bill, essentially the same language, flew through the House without opposition, but was stalled in the Senate Judiciary Committee, and it has never made it to the floor. Of course, we would, from our opinion, that's because if it makes it to the floor, it lets Georgia know exactly where we stand, and that 99.9% of all voters will support this and want it. And the only way it can be stopped, and the reason it's been successful in being stopped in Georgia, is it's been killed behind closed doors and not at open committee meetings like this. And I just shudder to think at the victims who have been, over the last 2 years, when we've tried to bring ours up into our law into the mainstream, have missed that opportunity, and the suffering unnecessarily they've been put to. I would tell you, Mr. Chairman, that we've looked at these statutes. There's nothing aggressive or untoward about this bill that has been put forward. There is not plowing new ground. It is basically just bringing us barely into the mainstream of what other states have done. And it's not been red states or blue states. It's everybody. We all are invested in protecting our children, and you act every day to protect Georgia's children. There's just not any reason why, under some hypothetical reason, that our situation is different in Georgia than all the other southern states or the rest of the United States. Matter of fact, I would urge that one of the reasons we have the trafficking problem that we have is that it makes financial sense for people that are engaged in the pocketbook. So, we think that, that there's a direct correlation between the laxity of our law, the rights of the children to go forward, and what's going on here. So I really appreciate, we've had many of these members that are subcommittee members, and Representative Oliver and Representative Evans, many of you, several others have all been very supportive, and we really appreciate it and have recognized the need. We're just hoping and praying that that this time with the more support, and I should say I've been told we have the support of the Baptist Church again. We certainly have the Church of one of the co-sponsors of the bill is involved with the Church of God and various other organizations, religious organizations. They're saying, look, we support them, and if our entities actively help that. So I think we've got a much broader base of support, and I think this legislation fits like a glove for the other criminal trafficking legislation that is going on out there, because you got to realize that many of the people that are trafficked are children, and almost all of the people that have been trafficked have been abused at some point. So these things, there needs to be a concerted effort to ride on the coattails of the momentum for the trafficking legislation, because trafficking is just one small subset of sexual abuse. You can't treat them separately. It's unfair to say that children that have just been abused but not trafficked are in a different position. So anyway, I'm happy to answer any questions later, Mr. Chairman, if it comes up. I really appreciate everybody's great intention on this, and we are here to help in any way possible. And I would tell you there are thousands of victims that have been involved in this for wanting these changes through the years, but they don't have the political voice. They don't have the lobby dollars. They're counting on us, right thing, to bring Georgia up to at least where the other states are. So thank you very much for your time.
All right. Thank you, Mr. Wilbanks. All right. We've got several more witnesses to go and we need to get through the list here. I'm going to start at the top and work my way down. Carrie Silverman, American Tort Reform Association. Are you there?
Yes,
There you.
thank you, Mr. Chairman. I appreciate the opportunity to testify today. My name is Gary Silverman. I'm here today to represent the American Tort Reform Association. I'm an attorney at the law firm of Shook, Hardy and Bacon, where I practice consumer, appellate, and product liability law. I'm also an adjunct professor at George Washington University. I'm here today to represent the American Tort Reform Association, which is a coalition of businesses and municipalities and associations with the mission of advancing balance, predictability, and fairness in the civil justice system. Child sexual abuse is intolerable, punished both criminally and through civil claims, and we commend the committee for considering how to best improve the law in this area. ATRA doesn't have any issue with further lengthening statutes of limitations to file child sexual abuse claims going forward, which is in part what House Bill 109 does. But we have concerns with the bill, and our concern is solely with the bill's inclusion of the one-year window during which old time barred claims would be revived. ATRA is concerned with the precedent that this bill will set in setting aside the statute of limitations and reviving decades-old claims for any type of lawsuit. And I understand that some may view statutes of limitations as arbitrary, cutting off what could be a valid claim after a certain number of years. Some may view them as just a way for defendants to get out from liability as a technicality. But the core reason that we have statutes of limitations, which can often be overlooked, is so that judges and juries can make decisions about liability, hard decisions, based on the best evidence available. It protects the accuracy and the reliability of the civil justice system. And that's particularly important in negligence types of cases, where a jury has to evaluate what an organization did or didn't do, and should or should not have done at some point in the past. And it's also understandable to view child sexual abuse claims as involving such horrific conduct or injuries that there should be an exception to that general rule that we have for every other civil type of case, that a claim has to be filed within a finite time period, and then after that period is over, claims can't be filed. But the issue is that tort law often addresses catastrophic lifelong injuries. I work in a defense law firm, and while it happens, people don't generally sue for trifles. It's not out of the ordinary for firms to defend cases involving claims that a medication caused the child's birth defect, that a defect in a car or a drunk driver caused an auto accident that killed an entire family, that the reason people develop cancer was exposure to a consumer product or a toxic substance, just for some examples. These are tort cases. We have statutes of limitations for them. In all these types of cases and others like them, Georgia law provides a finite time to bring it. Usually it's 2 years. And when a child is injured, that period doesn't start until the child becomes an adult. On the other hand, cases involving what most people would think of as less serious injuries, with less culpable conduct, cases involving land and property and written contracts, often have longer periods of time than 2 years to sue. Why? Because the statutes of limitations are typically not based on the heinousness of the conduct or the severity of the injury at issue, but it's based on the nature of the evidence involved. Claims involving hard evidence, written contracts, land, have longer statutes of limitations because you can look at it, you can see it. Claims involving duties of care, of conduct that are reliant on witnesses have much shorter periods. because you need to have the documents, you need to have the evidence, you need to have the witnesses there so that the court can decide those claims in the right way. So in Georgia, for childhood sexual abuse cases, as we discussed today, we've already set a longer statute of limitations than other types of tort claims. 5 years rather than the 2-year period of turning 18 to bring a claim, age 23. And in 2015, the legislature added that discovery rule, which gives a person 2 years of becoming aware of abuse to file a claim, no matter how long ago the abuse occurred. The 2015 legislation also took the controversial step of reviving time-barred claims, but it only did it against perpetrators during a 2-year period. It did not revive claims against organizations. Why did it make that distinction? Well, a perpetrator can attempt to respond to the victim in court. The question in these cases is clear. Did he or did he not commit the abuse? If you're reviving claims against organizations, there will be situations where the perpetrator is dead, where the employees of the organization at the time the abuse occurred are gone or dead, can't be found. The records have been long discarded, 30-year-old records. And whether the entity is a daycare center, a school, or a dentist's office, the ownership or management may have changed hands entirely. And a jury is going to be placed in the position, faced with a plaintiff who no doubt has experienced abuse and has to decide whether a nonprofit, a business, or a government entity took appropriate steps in how it hired or supervised an employee or volunteer with little or no evidence available to it. That liability is going to be evaluated in hindsight based on what we know and the safeguards we have today, rather than what was known decades ago. House Bill 109 takes the step that this committee did not take in 2015. It revives claims against organizations in addition to perpetrators. As I mentioned, ATRA has no issue with prospectively extending the period for filing claims, so long as it's a finite period, as it is in this legislation, and applies prospectively. We recognize that this legislation has evolved. It's no longer an open-ended reviver, but it at least does contain several significant constraints on its scope that are helpful. But we remain concerned with the precedent set by continuing down this path and reviving time-barred claims of any kind. There are many areas where statutes of limitations will seem unfair and arbitrary when viewed in an individual case, when we don't consider the broader public policy reasons that we have them and why the civil justice system needs them to function the right way. Finally, you've heard today that other states, and particularly southern states, have gone in a different direction. From my research, that's not true at all. Contrary to what you have heard, most states have not filed time-barred child sexual abuse claims. Over the past 20 years, reviver legislation has been repeatedly introduced. And in most instances, states have rejected these proposals and instead prospectively extended statutes of limitation. At this point, about 1/3 of states, including Georgia, have enacted some form of reviver. Most of these states, like Georgia, place significant constraints on the reviver, limiting them to perpetrators or having other types of limitations on them. And in fact, with the exception of North Carolina, none of Georgia's neighbors have taken the path of reviving time-barred claims. Not Alabama, not Florida, not South Carolina, not Tennessee, for example. They may have extended their statutes of limitations prospectively. I know, for example, that Florida is one of the handful of states that have eliminated their statute of limitations for child sexual abuse claims, but it did it prospectively, not retroactively. And it did that both for policy reasons and because in most of these states, there is clear law saying that doing so, reviving time-barred claims, is unconstitutional as well. So in sum, ATRA has no issue with prospectively extending the statute of limitations as House Bill 104 does, extending the discovery period, extending the period to bring claims from age 23. But it urges the committee not to continue down the path of reviving time-barred claims. Thank you for the opportunity to testify. I welcome your questions.
All right. Thank you, Mr. Silverman. Any questions from the committee? Yes, sir, Representative Lambert.
Thank you, Mr. Chairman. So, Ms. Silverman, I gather your organization would oppose the section D, which has, I think that's the revival, if I'm reading that correctly, but you don't necessarily oppose other parts of the bill?
That's section D. Yeah, it's, the reviver is on page, what I'm looking at, page 3 from line 60 down. That would be the provision that we are concerned about. The other provisions earlier in the bill, on page 2, we don't have an issue or position.
Okay. Thank you, sir.
I would
Any
like
other
to-
questions? Yes, sir.
Just as a response to the committee, because I've heard that before too. What about organizations who, you know, they change leadership? The person that was in charge of that group or whatever, they're dead, they're gone. Couple of thoughts on that. One, there's already precedent in our law for this. There is no statute of limitation on fraud. And I could argue in some way, shape, or form there's been a fraud committed by the crime of covering up after they were a mandatory reporter. Let's just lay that out there too. They committed, this was criminal act by not reporting. So that piece is already, there's already standard or precedent in our law there is no statute of limitations on fraud. The same scenario, if my mother was violated by an act of fraud by a company in the 1970s, 1960s, that company could have acknowledged these things. They could have fixed their bylaws. They could have hired new leadership. But I could still, if I find out today that my mother was frauded, we could file suit against those companies and collect damages. So there's precedent for this in Georgia law. Furthermore, I would argue that if this organization had just simply obeyed the law, because they were mandatory reporters, whether we're going back to 1973 or 1988, wherever they were mandatory reporters. If they had obeyed the law as written in the state of Georgia, there would be no liability, but they broke the law and committed the act of covering this up, and they knew it happened. You have to be able to prove to a clear and convincing standard that they knew it was happening and they worked to cover it up, and they broke the law and did not do so. So that's my response to that.
All right, thank you. Any other questions for Mr. Silverman? All right, thank you, sir.
Thank you.
All right, we move to Catherine Robb.
Thank you, Chairman Gunter and subcommittee members. My name is Catherine Robb. I'm the Executive Director of Child US Advocacy, the sister organization of Child USA, the national think tank on these matters. I'm also a mother and an attorney, and I am a survivor of child sexual abuse. At age 9, I was sexually assaulted by someone I knew and trusted, and that abuse went on for 5 years. So my voice here is not just as an expert, an advocate, and an attorney, but also as the voice of that little girl and every other little girl and boy in Georgia, quite frankly. But as the Executive Child US Advocacy, we work on SOL reform all over the country. And there is clearly a national trend by lawmakers in responding to this epidemic of child sexual abuse. And I would strongly disagree with the comments made from Mr. Silverman, with all due respect. Since 2002, 19 states have passed revival legislation, and some have passed multiple windows, bringing the total to 24 states, 19 windows, and 5 of those were revivals. In 2019 alone, 9 states passed revival or window legislation. In this year alone, 24 states have introduced SOL reform legislation, and 12 of those are windows. The national trend is clear. In response to this epidemic, it's clear. The courts are still working. The sky has not fallen. The safeguards are still in place. The safeguards of the rules of civil procedure, rules of evidence remain in place. And quite frankly, plaintiffs must still prove their cases. As to catastrophic torts, child sexual abuse is very, very different. The victims are silenced by their perpetrator. These are not car crashes. These are not slip and fall cases. We're talking about, quite frankly, the rape of children, and the public policy to protect our children and to give justice to survivors should certainly outweigh any due process concerns. I would also say that society looks to lawmakers as yourselves, and we look to the harm and the new data and the new science, and we look to you to pass sound and just public policy legislation when we learn about new data. Of course, we did that with child seats for babies, seatbelt laws, sell cigarettes to minors, texting and driving, vaping, you name it, the list goes on and on. When we see a harm or a danger, we look to lawmakers. We look to you. You keep us safe. You keep kids safe. Window legislation really serves three purposes. It identifies previously unknown predators, but it also shifts the cost of abuse away from the victim and the taxpayer to the bad guys. And finally, it educates the public. It educates parents, grandparents, caretakers. It educates the public about the severity, depth, and scope of this problem. We know now that there's an epidemic of child sexual abuse, that 1 in 5 girls and 1 in 13 boys will be sexually assaulted before their 18th birthday. That's 13% of all children. We also know about the monsters. Those are the guys that look like the good guys, the Sandusky's, Nassar, Epstein, the Pennsylvania grand jury report. The list goes on and on and on. We also know now better than ever, thanks to the science of traumatology, the effects that child sexual abuse has on children. We understand the social science data. We understand the science of stress. We understand how the brain, especially the brain of a child, responds to stress, that constant release of high cortisol levels that is caused by chronic or toxic stress, how that damages the very architecture of the brain, and it shrinks the hippocampus and affects neurons and neurotransmitters. And what we know about that is then affects the memory of a child, concentration, attention, and then that causes all sorts of other beyond neurobiological effects, psychological issues and medical issues, from post-traumatic stress disorder, depression, behavioral issues, acting out in school, anxiety, sleep and eating disorders, relationship issues, employability struggles, and sadly, suicidal ideations. We also know that the cost on average to the victim is about $830,000. We know that that's the lifetime cost. However, we also have some really good data on the financial burden on the state of Georgia, and I think that should be noted. Child sexual abuse burdens all sectors of society: educational systems, medical systems, social science systems, social service systems, law enforcement, workforce, employment, and the penal system as well. Most statistics have the number at about 68 to 72% of incarcerated people were sexually abused as children. Some studies suggest that the cost across the board is about $9.3 billion annually for our country in dealing with this just epidemic. I think as speaking as, as an attorney, as a mother, as a survivor as well, that protecting children and granting justice to those victims really outweighs any due process concerns. Like I said, we have safeguards in place. We have rules of civil procedure. Plaintiffs have to survive a 12B motion. We have rules of evidence. You know, again, the sky is not falling. The court systems are working well. A previous speaker spoke about what happened in New York. Very, very small percentage of the population, let alone, of those civil filings since August 2019, very small percentage represent all filings, and much smaller is how it represents the entire population of New York. So the courts are not being flooded. The systems keep working. Really what's happening is the bad guys are being identified and they're being forced to clean up their acts. And I really hope that Georgia can make this step forward. Anyway, thank you. Thank you for giving Children and Justice your time, your vision, and your leadership. If there are any questions, I'm happy to answer them.
All right. Thank you, Ms. Robb. I appreciate it. Any questions from the committee? All right. Hearing none. Thank you, Ms. Robb.
Thank you.
All right. I want to now jump to Darren Penn, get his testimony.
Thank you, Mr. Chairman Gunter and members of the subcommittee. I appreciate you giving me the opportunity to speak today. Can you hear me okay?
Yes, sir, I can. And because we have a lot of witnesses and short on time, if you could make it relatively quick.
I will do that, Mr. Chairman. In fact, there are other witnesses behind me that I think are far more important than I am. I come to you today as an attorney in Georgia. I represent a number of survivors of childhood sexual abuse. I first got involved in all of this back in 2015 when I first met Professor Hetherington and kind of got involved with her down at the Cease Clinic. And I've been doing everything within my power to help victims of childhood sexual abuse since that time. I can tell you that we have tried to use current Georgia law to try to prosecute these cases and do the very best that we possibly can. And for the last 6 years, that's what I've been working my tail off on. And we've primarily tried to use three different theories. One is fraudulent tolling of the statute of limitations, as Representative Clark has already mentioned to you. The statute of limitations never runs on fraud, and it's told in our state, or supposedly told in our state, on fraud. The other theory has been RICO, and the other theory has been public nuisance. If you want to see how far we've gotten with those theories in the state of Georgia, well, there was an opinion that came out from the Georgia Court of Appeals on October 29th of 2020, Doe versus St. Joe's, that essentially lays out, at least for that specific fact pattern, what the Court of Appeals, their opinion is on our current state of the law. And that just underscores how important it is for this body to do something. And I really appreciate Representative Clark coming forward with this language and bringing this to you. There's a couple of things I wanted to address as somebody who handles these cases day in and day out, who works within this statute on a daily basis. And Professor Hetherington, she did bring up earlier that, the 2-year window has not come up yet. And that's true. As we operate within this statute today, that 2-year window has not come into effect because of the limitation of when that discovery rule applies. But more importantly, and I think Representative Oliver brought this up with your question about the Boy Scouts cases. There is a sense of urgency today, right now, with the Boy Scouts bankruptcy, that something needs to be done, especially in Georgia. What we know of, there are, I think, approximately 125 survivors or victims from different Boy Scout situations who have asserted claims in that bankruptcy. And the time for asserting those claims has expired within the bankruptcy. So all the claims that are going to be filed, they're already in. And one of the number one factors for evaluating those claims is going to be the strength of the state's laws. And as we sit here today, the strength of Georgia's law is it's about the fourth worst state in the United States as far as these kinds of laws and protecting victims of childhood sexual abuse. And so specifically enacting a statute this year will help those claimants in the Boy Scouts cases, the ones that are from the state of Georgia. It'll put them on at least a more equal footing with the other states, and hopefully will allow their claims to be evaluated equally with the other claims. And I will, just a couple of things that I wanted to I would suggest as friendly maybe suggestions or alterations to the language that I think would be great for the statute. And I think it would really underscore Representative Clark's, what his intent is here, is if you look at line 72, and I think it's just a grammatical error or just maybe a misnomer that was put in there. But on that part of the statute, it's talking about entity liability and under what circumstances they can be held liable pursuant to the window. And on 72, it specifically says, or withheld information about the prior act, comma, resulting in the plaintiff's injury. Well, what we know from reality and the research in these cases is that the entity, it's not responsible for all of the harm that happens to these survivors, but it contributes to their harm. And so I would, as a friendly suggestion, I would offer to the members of the subcommittee that language, if it was changed from resulting in the plaintiff's injury to contributing to the plaintiff's injury, that would be more appropriate and would really help Representative Clark's purpose. The second thing that I would bring up is line 74, 75. They've already been brought up before the subcommittee. They've been talked about in this, the cutoff at 1988. The reality is with OCGA, our mandatory reporting law, it's OCGA 19-7-5. It was originally enacted in 1965. And since that time, there have been 10 amendments all the way up to 1990, where various changes were made to the statute. And more specifically, they were changing who was a mandatory reporter under that law. And my suggestion really to the subcommittee that I think would really help underscore Representative Clark's purpose would be if after July 1, 1998, the language on 75, if you added something to the effect of, unless they constitute a violation of Georgia's mandatory reporter laws in existence at the time. And that way there's no debate about whether they were a mandatory reporter or not, whether the law was broken or not, or whether it's an arbitrary cutoff at 1988. You can cut the activity off at 1988 unless under one of these previous versions of the law, it was a violation of the law. And I think that would better serve Representative Clark's purposes, and in particular, going back to the Boy Scouts claims, as it is written, if there's a cutoff at 1988, the majority of the Georgia claimants in the bankruptcy for the Boy Scouts cases would not be covered, and they would be left out. And so those are the two friendly suggestions I would make to the subcommittee. I really appreciate your consideration of this incredibly important issue. And I'll answer any questions if you have any.
All right, thank you, Mr. Penn. Does anyone on the committee have a question? All right, Mr. Chairman, Administration.
Thank you, Mr. Chairman. Thank you, Ms. Penn, for your testimony. So I wanted to ask you about the sovereign immunity waiver toward the end of the bill. And I know that's been a heavily discussed topic in other legislation over the past few years for us here at the Capitol. Would you please just talk us through that, what the need is, and maybe what as specific as you're able to be about what the implications of this would be and what local government groups and different groups, what input they've given on that. Thank you.
I'd be happy to, Mr. Chairman. And essentially, I actually helped work on the 2015 version of this law that was originally passed. And I can represent to members of the subcommittee that the original intent, if you go back and look at the definition of entity, it included all public entities at the time. And so the original intent that it was a waiver of sovereign immunity. Since that time, it has come up and it has come up in debate, and there have been questions. Does this language cover, does it provide, or does it waive sovereign immunity or not? And in fact, some of the people that have raised questions about the bill over the years have had that specific question. Does it in fact waive sovereign immunity? And if you're going to allow a look back for some entities, you need to cover all of the entities, including the governmental entities. And so I think that's why that language is put in there, to clarify that. It was put in there last year to make sure that there is no dispute about it. And I can add to you that in real practice, we have a case right now. It doesn't involve a claim that would be beyond the traditional statute of limitations, but that very issue is being debated with this law. Does it in fact waive sovereign immunity or not? And out of fairness for all of the entities, including the business entities as well as the governmental entities, and for the survivors themselves, it should in fact waive sovereign immunity and provide that equal access to justice across the board.
All right. Have another question from Representative Leverett.
Thank you, Mr. Chairman. You had mentioned three, I guess, current methods of trying to get around statute of limitations problems caused by existing Georgia law. One was fraudulent tolling of the statute, RICO, and public nuisance. I'm just curious, is RICO, are you using a state RICO or federal RICO?
It's a state RICO, and it's more fact specific for those cases because they actually involve some communications that implicate the RICO statute, but it's state RICO and not federal.
And what does that do to your statute? In other words, how does that potentially extend it? Does it do it in the same way a fraud claim would, or is it just a specific number of years?
Under the RICO statute, the statute of limitations run, it's 5 years from the last predicate act.
Okay.
So it provides a different calculation for the statute of limitations.
Okay, thank you, sir.
You're welcome.
Any other questions? Not hearing any. Mr. Penn, thank you very much.
Thank you, Mr. Chairman.
All right. Now I'll move to Francis Mulcahy.
Thank you. Thank you, Mr. Chairman. Let me put the camera on too. All right. All right. I'm here. Well, thank you, Mr. Chairman. Members of the committee, appreciate the opportunity to speak to you. I am Frank Mulcahy. I'm Executive Director of the Georgia Catholic Conference, and I represent the Catholic Bishops of Georgia. We have two dioceses in Georgia, the Archdiocese of Atlanta, which comprises 69 counties in North and Central Georgia, and the Diocese of Savannah, which comprise 90 counties in South Georgia. These two dioceses minister to approximately 1.3 million Catholic people in Georgia through 175 parishes and missions. These two dioceses support 34 elementary and secondary schools, serving more than 16,000 students, both Catholic and non-Catholic. We have a Catholic Charities organization and a St. Vincent de Paul Society, which provide funds and support for those in need. I believe that Graham Thompson has shared with you a little visual giving the details of the services which we provide through Catholic Charities and through St. Vincent de Paul. And we have to be proud. This money all comes from Georgians, and We're proud of the amount that has been provided, particularly in this past year when we have all been suffering from the effects of COVID, and particularly those who are in need. So I'm not going to try to go through that kind of detail. You can read that and trust in that, and that's what we have been doing and will do. Turning now to House Bill 109, I first want to thank Chairman Clark for addressing this issue. This is a very sensitive and very difficult issue. Our bishops have said and continue to say that this plague of childhood sexual abuse, wherever it occurs, is abhorrent, it's evil, certainly contrary to the teachings of the Catholic Church, and I think to most of our, if not all of our churches. We have had instances of isolated instances of abuse over the last 6 decades in Georgia, but we have stretched out, particularly since 2002, in establishing a system which we believe provides greater protection for children. In October of 2019, Chairman Fleming asked me to speak on what we were doing in terms of child protection at a committee meeting. I realized that some of you were there, some were not, but I'm not going to try to repeat that exposition, except to mention a couple of high points. One is that we have a zero tolerance policy. Any of our clergy or lay people who are credibly accused of childhood sexual abuse are terminated forever from our employ and our operation. We have a 24-hour hotline, and that hotline will respond to anyone who calls with an allegation of sexual abuse. Obviously, if it is someone related to the church in Georgia, we will reach out to them in terms of providing money or services for psychological help and for any other kind of assistance they need. If they are from a different diocese of the United States, we will refer them to that diocese where they will get the same treatment. This is a requirement of our, what we call the charter, which was adopted in 2002. If they are not related to a Catholic church, whether it be a family member who has been abusing this person, or whether it's a different church, we will still do what we can to help them. We don't turn anyone away from our 24-hour hotline.
Mr. Mulcahy, I'm
Yes.
sorry to interrupt, but can you speak mainly to the bill?
Sure.
Thank you.
Sure. I said I appreciate the work that Chairman Clark has done. And I want to particularly note that Chairman Clark, and as just mentioned a few minutes ago by Mr. Penn, have continued to require in their bills that the bill cover all kids, all children, whether they go to Catholic institutions or any other kind of institution, including state institutions. And I agree with Mr. Penn's analysis of that last provision in the bill regarding the immunity. I don't think the original proposal from several years ago of just citing the entity was sufficient. I think this language is good language that gets us there. I have also sent to the committee secretary this afternoon, or shortly before your meeting, some amendments that we would propose to the bill. These are not substantive amendments, but I think they are clarifying amendments, and I think they are helpful. And I would be happy to talk about them, but I'd also be happy to meet with Chairman Clark or anyone else on the committee as you develop the bill to talk about these provisions. I think we have provided them to you, Mr. Chairman, and to Mr. Clark earlier, but I'd be happy to talk about them and certainly work with Mr. Clark to get them through. The one issue that I would raise though is the question of why 1988? I'm sorry. Yeah, why 1988? And I guess I may have misunderstood Chairman Clark when saying that everyone admitted last year that a lot of organizations were not making the reporting that they were required to back in 1988 or prior to that. And if that's what he said, I disagree with that, certainly with regard to the Catholic Church. And part of that is I think we are seeing a misrepresentation of the reporting statute. We went back and we looked at the expansion of the statute, which has expanded from 1965 through the current day. But the 1988 section added some additional mandatory reporters. Interestingly enough, clergy were not included. Clergy were not specifically included in that statute. In fact, we went back to the Atlanta Journal-Constitution in April of 1988, and Senator Steve Thompson, who was the sponsor of the bill in 1988, said that clergy were specifically not included in the bill as mandatory reporters because, to use his language, they were not paid for their services, and they did not have the training to be able to identify abuse when it occurred. To this day, clergy are not included in the mandatory reporting statute, although certainly clergy are included to the extent they may come under some other category. There was no criminal requirement in 1988 for a mandatory reporting. I don't believe there is a misdemeanor charge for failure to report now, but to go back and put civil liability in this case on those who may have not reported what they were not required to report is a problem with due process. And Mr. Clark is correct. There's no statute of limitations on fraud, but as in the case which Mr. Penn was referring to, it's a question of fact. The fraud may be the nuisance, maybe the RICO is available as a basis for a claim, but you've got to prove your facts. And if you don't have the facts to prove your case, you're not going to win under any theory. And going back to the 1988 statute, as I said, it did not apply to clergy. It applied to individuals in certain professions, did not apply to their employer. In fact, rolling up to 2014, in the May versus the state case, the Georgia Supreme Court, the court was very clear that the obligation for reporting went to those who were identified in the statute. In that case, there was a teacher who had been told of abuse that occurred. She did not report it, but the student was not a student in her school. And the Supreme Court said the statute does not apply just because a person is a teacher. There has to be the connection between that person and the victim. In addition, the supervisor was not liable for reporting. So to go back and say that entities who are not named should become liable is a huge step in expanding liability that did not exist at the time. I'm not going to repeat some of the things Mr. Silverman said. I thought he had some good points that we would agree with, particularly with regard to the states around Georgia. Most of them, as Georgia, have increased their increased their liability for childhood sexual abuse, and we have supported anything going forward. We did not oppose any of the legislation back in 2012 when they expanded the state forward, the criminal liability. We do not object to anything expanding the state of the statute of limitations going forward. But it is the retroactive application of the statute of limitations to situations where many of the people involved are dead, particularly within the entity. Individuals may or may not be alive, but and they know whether they did it or not. You can put them on the witness stand and let the jury see their credibility, but the individuals in the entity, and particularly in nonprofit entities where the money has not drifted off to shareholders or owners, but is used for the purpose of the nonprofit. So again, I'm happy to work with Chairman Clark to try to improve this bill, but I must say we do have a huge concern with the look back provision in the bill as we have in other bills. Thank you, Mr. Chairman. I appreciate your time and effort.
Thank you, Mr. Mulcahy. Representative Evans.
Thank you, Mr. Chairman. Thank you, Mr. Mulcahy, for being here. We all got on our desks here the handout about the Catholic charities, and since we're here to debate House Bill 109, I have to assume you meant for this to inform us on our vote for House Bill 109. Are you telling us of the good work that the Catholic charities do to send a message to us that entity liability would preclude your ability to do this good in the community, and that somehow that is a trade-off? I'm trying to figure out why this is on our desk.
Yeah, I would not say it would preclude, but obviously money that goes into lawsuits and to legal fees comes away from other charitable works that we can do.
Are you trying to tell the committee that victims in the past should not be compensated because that will preclude you from doing good to other people in the future?
No, we're not saying that at all. What we're saying is there needs to be some kind of a balance. We provide today, and we have for years, try to help those who have been victimized by child abuse. And that's one of the things that makes this difficult. We don't know what lawsuits might be out there. There's no way to value the risk reward in this.
One final question, if I might, Mr. Chairman.
Sure.
You mentioned that you now have a zero tolerance policy, and that if there is in your words, credible allegation against someone, you have zero tolerance, that person is terminated. How many people have the Catholic, has your organization terminated as a result of your new zero tolerance policy?
Well, it's a zero tolerance policy that goes back at least to 2002 and probably before that. And I don't have a number on that.
If you could get that for us, I would appreciate it, because
will
we are all here trying to help
Sure.
kids going forward. And I would just like to know what you are doing inside your organization.
Sure.
for children.
Yeah, we have a lay advisory board that reviews all these claims. I'll try to get that number for you.
Thank you.
Any other questions? All right, seeing none. Thank you, Mr. Mulcahy.
Thank you, Mr. Chairman.
All right, let's go to Mike Franklin. Do we have Mike Franklin? I don't know. Let's see if he's outside.
There was a Mike Griffin earlier, but he had to leave.
Yeah, that's okay. No? All right, then Jay Knorr?
Good afternoon. Can you hear me?
Yes, sir.
Chair, thank you for having me. Members of the subcommittee, I appreciate the opportunity to speak on this important legislation. I am an attorney in Georgia. I'm also the president of CLAWS, a Georgia nonprofit that promotes and advances the use of the civil justice system to help prevent human trafficking and help human trafficking and sex abuse survivors. We were, as members of CLAWS and as special assistant district attorneys in 2018, we filed one of the first civil lawsuits for hotels benefiting from trafficking on their premises using nuisance laws. And then in 2019, we helped and worked with, for example, Representative Reeves on House Bill 234 in Governor Kemp's office and passed important improvements and changes to the nuisance statute that we used. And of course, we're not here to talk about that. And I'm gonna, in support of House Bill 109, I'm gonna limit a lot of the comments, I'm sure thankfully for members of the committee, that I was gonna share in the interest of time. I mean, there's two components to the support that CLAWS has for this legislation in recognizing a need to help victims. One is just the number of childhood victims in the state, of course in the country, but in the state of Georgia that the bill would help. And then the second thing that I don't think has been touched on yet, although members of the committee are probably aware of these facts and this social science, and I apologize if you're hearing it again, but one of the things I wanted to talk about in terms of the importance of this legislation is what is now a consensus view in the literature, social science literature, that the people who experience sexual abuse in childhood do not disclose or report until adulthood. And when that disclosure does occur, and reporting delays of decades are common. And I've got a number of studies, but I just want to highlight them in the interest of time. And they're very meaningful to me and impactful, I think, for the importance of this legislation. There's a study that was done involving over 4,000 adolescents surveyed about sex abuse that they suffered as children. The majority of those victims, 60%, told no one of their abuse until the survey itself. And of the minority who did disclose the earlier abuse, 80% only mentioned it to a friend their own age, not to an adult, not to authorities. Another study of 122 women who experienced child sexual abuse found only that 32% disclosed the abuse during childhood before the age of 18. And 68% did not report it until adulthood. And here's the key finding of that study. The delay for those who did not report it until they were adults was up to 49 years. An Irish study that I reviewed found that 40% of those who had experienced some form of sexual assault as minors told no one of their experience until the survey. And then the final study I'll mention talked about the same facts, the same components that were observed in the delayed reporting and disclosure. And this is a study from Ireland. The delays range from 20 years to 50 years. So the importance of the literature that we now, social science researchers and authors now recognize is that how long that these serious events are delayed in their reporting. And that, of course, there's many reasons for that. I was going to talk about that, but regardless, it underscores the importance of this legislation from CLAWS's perspective. And it shows, as members of the committee have already recognized and many of the witnesses elaborated on, how important this is in providing for a distinct need, and particularly with respect to the revival portions of the statute. And we think those are clause things that those portions of the statute are very important because, among other things, because of the delay that is so common in reporting these types of claims. Victims have to walk their own path of healing and nurturing before the time that they are mature enough and complete enough to report these things, to pursue a claim and the compensation that they deserve. The law needs to be amended and ameliorated to reflect the trend in other states so that these victims here in Georgia are allowed to pursue their claims. 10 years is not enough, we think. So clause supports the extension of the statute of limitations in House Bill 109 that will accommodate the problems with late reporting and disclosures for childhood victims. And thank you for your time and hearing me out, and I'm happy to answer any questions.
All right, thank you, Mr. Knorr. Are there any questions from the committee? Don't think I'm seeing or hearing any. Thank you, Mr. Knorr. All right, next want to go to Alan MacArthur.
Can you hear me?
Yes, sir.
Mr. Chairman, thank you for having me. So I am a victim of childhood sexual abuse. And forgive my rambling. When I was asked to come here today, I didn't know what it is I could say or needed to say would help to move this bill along, or to convince y'all, as to the importance of it. I was a little history as I was abused starting when I was 12 years old by my scoutmaster, Ernest Boland. And it lasted for about 4 years until I was 15. And because of that abuse, I have suffered with depression and anxiety, with suicidal ideation, PTSD, substance abuse and alcohol abuse, risky behaviors, and just kind of unrelenting shame. The shame, this feeling that not that I had done something wrong, but that there was something inherently wrong with me because this was allowed to happen to me. And when it regards to the entities, Boland was allowed to go to 3 different churches over a 3-decade period because the entities refused, because the Boy Scouts refused to do anything. And they knew, they just refused to act. When it came down to I was in the last church where he was a scoutmaster. And there is the pastor there had given a interview to a local Baptist magazine later, saying that they knew what he was doing and where he was taking us, but because out of respect for his family and because he was a pillar of the society here in Athens and because he was a leading business owner, they decided to do nothing. And because of their inability to act, many boys were abused by this man. And I come here today personally out of at a risk, because one of the churches in this lawsuit is my own personal church, one that I'm actually employed by. And it's difficult for me to do this, but I do this because this law, because Georgia's a predator-friendly state, and this law has got to change because children are constantly being abused in the states, and because of the law, the way it stands now, all the predator has to do is kind of bid their time, and then they'll get away scot-free without having, any kind of repercussion because of it. And I just, Mr. Silverman and Mr. Mulcahy and others here who are opposed to this bill, I would just invite them to come and stand in my shoes for a day to see what this is really like, what it feels like to be a victim of someone who was sexually abused. You know, I'm 57 years of age. Never made the connection between what had happened to me and all the different effects I was suffering until I was 52, you know. And because I had done so much personal work on myself, you know, I am able to come here today and to speak up. But there are just hundreds of other people, others, survivors who just, they can't. They don't have the voice. You know, they're too afraid to come forward. So I think that's kind of all I have. And thank you.
Thank you, Mr. MacArthur. I know how tough that must be for you to testify. We'll ask if there's any questions by the committee for Mr. MacArthur. And I don't see any. All right, I'll call on Rob Lawson.
Good afternoon. Can you hear me okay?
Yes, we can.
Okay, great. Yes, my name's Rob Lawson. First, I'd like to thank the chairman and the subcommittee for their willingness to deal with such a difficult topic, child sexual abuse. The subject of pedophiles and child molesters is one that has historically been the most taboo subject in our society. However, with the publicity given to such cases as Jeffrey Epstein, Jerry Sandusky, and Larry Nassar, this taboo subject has come more into the light and into our national consciousness, and people are no longer as afraid to discuss this horrible topic. Also, the Me Too movement brought the topic of sexual assault out into the light and has toppled giants such as Harvey Weinstein, Kevin Spacey, Bill Cosby, and Matt Lauer, just to name a few. It was hard to envision just a few years ago that we would be having the types of conversations that we are having today about child molesters and pedophiles. But the national dialogue has shifted from cover up and denial to a true assessment and understanding of the harm that these crimes cause and the severe effects that they have, not only on the victims and their families, but the ripple effects that they have on society at large. As for my own story, I was sexually assaulted in 1985 at the age of 15 by a Boy Scout leader while I was attending the 3-day initiation ceremony to become a member of the Order of the Arrow. The 3-day ceremony is called the Ordeal, and my ordeal took place at a Boy Scout property called Rainy Mountain in Raven County, Georgia, nestled in the foothills of the Appalachians. Completion of the ordeal is a requirement to be admitted into the Order of the Arrow. The Order of the Arrow is the exclusive scouting fraternity whose membership is only offered to a few select scouts considered to be the best in their respective troops. Not even all Eagle Scouts are offered membership into the Order of the Arrow on their path towards Eagle Scout, and there is a strict vow of silence and secrecy associated with the order and its initiation and ceremonies. The Scoutmaster who abused me, Fleming Weaver, started as a volunteer in scouting in the early 1960s in Georgia. Then he moved to Alabama, where he was also a Scoutmaster. And then in 1969, he moved back to Georgia, where he became the Scoutmaster of another troop in my hometown. When I first met my abuser, while he was recruiting boys to become members of the Order of the Arrow, I had no idea that 4 years earlier, he had been removed as Scoutmaster from the other troop in my hometown because he admitted to molesting scouts in that troop. However, after 1 year out of scouting, he was allowed back in, where he assumed regional leadership roles. And he soon became president of the Northeast Georgia Council, as well as the primary advisor to the council's Order of the Arrow Lodge. And he even had his own cabin on site at Camp Rainy Mountain. It wasn't until a decade after my abuse that Weaver was finally investigated by the Hall County Sheriff, the Georgia Bureau of Investigation, and the Hall County District Attorney. During that investigation, while being questioned, he admitted to molesting at least 5 or 6 scouts while he was the scoutmaster for Troop 26. However, the district attorney, without searching for additional victims, decided that the statute of limitations for criminal prosecution had passed and quickly and quietly closed the case, allowing Weaver to continue his charade as a model citizen. The Boy Scouts have admitted that there were multiple reports made against Weaver as far back as the 60s. However, these reports still have never been made public, and the Boy Scouts still refuse to release Weaver's file. His file remains part of the ineligible volunteer files that the Boy Scouts maintain but keep secret from the public, allowing these monsters to volunteer with other organizations and commit other horrible acts in our communities. In the fall of 2015, 2 of my nephews joined the Boy Scouts. Then in October of 2015, Pope Francis came to the United States, visiting DC and New York, and he apologized for the child sexual abuse scandals that had rocked the Catholic Church. It was at that time that I first came forward. First to my wife, then to my mother, then to my former scout leader, and then to a high school friend who was a reporter at the Atlanta Journal-Constitution. I did that so others would know what had happened and hopefully put a stop to the abuse. After my assault, it was difficult for me to process what had happened to me. And in hindsight, it has taken me decades for me to fully understand and process what happened and how it has affected me. I'm still dealing with it today. I finished my scouting career and attained Eagle Scout, but after the assault, I was never the same. I was forever changed. It is something that never leaves you, a cloud that follows you for the rest of your days. Not only does childhood sexual abuse essentially steal your childhood, but the cycles of depression and anxiety continue to affect relationships far into adulthood, if not for the rest of your life. In addition, the results of the sexual abuse often manifest in inability to make or maintain close relationships, a fear of intimacy, and recurring nightmares. All of this happened to me, as well as misplaced anger, rage, and a resentment of authority. In 2019, the chief executive for the BSA wrote a letter to Congresswoman Jackie Speer and claimed, quote, "The BSA would never have knowingly allowed a sexual predator to work with youth," end quote. After public outcry, Mr. Sarbaugh corrected that claim a few days later on May 28, 2019, and admitted that, quote, "The BSA did, at least in some instances, allow individuals to return to scouting even after credible accusations of sexual abuse," end quote. In February of last year, the Boy Scouts filed for bankruptcy to try to shield themselves from the mounting tide of childhood sexual abuse lawsuits against them. In March, the Department of Justice held interviews in Delaware to choose 9 survivors to sit on the Tort Claimants Committee to represent all survivors in this bankruptcy case. I was one of the 9 members chosen to serve on the TCC. The TCC meets at least twice a week to receive updates, provide input, and take votes with the interest of all survivors in mind. Thus far, we have had over 150 meetings. Being on the Tort Claimants Committee, I have seen firsthand how important this Child Victims Act, House Bill 109, will be to all the BSA survivors in Georgia to have a chance for justice. For the sake of survivors here in Georgia, please allow this bill to include conduct back to 1974, the statute date that made the BSA and others mandatory reporters by law. In closing, as difficult as it may be to do, I ask that each of you imagine how you would feel if it was your sons, nephews, or grandchildren that had been raped or molested by one of these sexual predators, how would you feel? Healing begins with justice. You, as lawmakers, have it in your power to help to seek justice and hopefully bring some healing and closure to the survivors who, through no fault of their own, have to live with the damage caused by these organizations and the pedophiles that they enabled. Thank you for your time.
Thank you, Mr. Lawson. Anyone have any questions for Mr. Lawson? All right, thank you.
Thank you, Chairman.
Now I'll call on Chris Gaba.
Hello, can you hear me?
Yeah, can now. Yes, sir. Go ahead.
Thank you, Mr. Chairman and members of the Judicial Subcommittee for allowing me to speak today. My name is Christopher Gaba, and I'm a husband, I'm a dad, I'm a son, I'm a brother, I'm a friend, I'm an entrepreneur and business owner, I'm a business partner, and I'm much, much more. But I'm also a victim and survivor of childhood sexual abuse. When I was 13 years old and a freshman at Darlington School in Rome, Georgia, I was selected, groomed, manipulated, coerced, and sexually abused by an adult, my English teacher. Because of my upbringing, the times, the environment, the paralyzing toxic shame and guilt, I kept this secret for most of my life. I put it away. But then in May of 2017, I received a letter from Darlington School that they had been made aware of inappropriate behavior between a teacher and a student in the 1980s. The teacher taught at the school for 20 years. I came forward at that time with 10 others who had suffered the same kind of abuse. None of us knew each other. None of us knew that it had happened to anybody else. We all thought we were the only one. Many of those victims reported the abuse to the faculty and the administration over those years. Even this teacher had been arrested for sexual assault of a 14-year-old boy, and he remained employed at the school. And today, he and the school continue to operate as if none of this had happened. And the 21 of us, there are 21 of us now, victims that have come forward, need to be dismissed. I've sat in court proceedings, court hearings, and listened to lawyers on the other side argue that I was irrelevant and out of time. And that brings me here to today. And please do not misunderstand me, because I am incredibly grateful for each of you, this bill that stands before you, and the work that you're doing in Georgia to make this law better for everyone. But I have to tell you that this bill falls disappointingly short. The current version and its arbitrary 1988 cutoff will leave hundreds of victims in the Boy Scouts of America, victims of the Catholic Church, and myself with 20 other brothers in the Darlington case who are currently fighting in the Georgia legal system for a fair and equitable chance for healing, closure, and justice. So I'll leave you with a question and a request. First of all, if the intention of this law is to protect children, punish bad behavior, and provide a fair and equitable path to justice for the victims, then why should the abuse and resulting shame, guilt, and pain that I've suffered for the past 40 years be viewed any differently in the eyes of the law or justice than the childhood sexual abuse that occurred yesterday, or 3 years ago, or 20 years ago? And I'm going to assume here that most of you all are parents, and I've shared with you that I'm a parent. I'm going to share with you a couple of personal things. I have 2 sons. They're 11 and 12. I drop them off in the car line every morning. And every morning I have to go back in the back of my head and wonder, are my kids truly safe every time I drop them off? That's what I have to live with. 3 years ago, when this all came out, I had to tell my 80-year-old mother what had happened to me. 4 weeks ago, my mom passed away. And one of the last discussions we had was about this case. And one of the last things she said to me, was that she was sorry she couldn't protect me and that she wished she could make this all go away. But you all know as parents that we can't and we don't have the power to take away all of the pain and hurt that our kids feel. But I will tell you that you all today have the power to make a huge difference. You have the power to give me and these other victims a chance at healing, at some peace and justice. So my request is that you all use that power here for something good. Please do not exclude us. Please do not dismiss us. And please give us a chance, a fair chance for justice in the state of Georgia. Thank you.
Thank you, Mr. Gama. Make sure that no one has any questions for you. Do I see any questions? All right. Thank you, sir.
Thank you.
All right. Checking to see Mike Griffin, I think he's gone. All right. So I think that takes us through our list of witnesses. I don't know of any others out there. I want to thank the victims for coming forward. I know how difficult that must be, but it puts a human face on what we're dealing with here, and I really appreciate that. Representative Clark, is there anything else you want to tell us?
No, sir. Thank you. Thank you, members of the committee for today. And I'll work with y'all on addressing some of the concerns that's been brought forward.
All right. We appreciate everyone's input, and we will be scheduling this back for another hearing, most likely next week.
Okay.
All right. Thank you. We're adjourned.